Hello, everyone. Welcome to another Talking Feds one-on-one. A lot in the news these last few days involving universities, and not just any universities, Columbia University and now especially Harvard University. And Harvard is the roosting place until recently, until he retired, of the professor we're really lucky to talk to today, the William Nelson Cromwell Professor of Law Emeritus at Harvard, where he specializes in, or specialized, he's retired now, in constitutional law and theory. He's the author of a recent important book that I hope we can talk to him about if there is a vacancy in the Supreme Court, that argues pretty provocatively and against the thrust of most opinion on maybe both sides of the aisle now, that all this focus on theories of constitutional interpretation, be it originalism or others, is a little bit, well, I'll ask him, but maybe a little effete or really not of great importance, even though senators spend so much time trying to probe it, and in fact, inconsistent with the court's practice over its couple hundred years. In any event, we are going to talk about the university setting, but I wanted first just to, welcome Mark Tushnet, who I've known for years and is one of the great constitutional scholars in the country, and B, maybe just ask you quickly about the book and if I got it right. So I'll excuse the prolix introduction. Thanks so much for being here.
Sure. I'm glad to be able to have this conversation. Yeah, you basically got it right. I mean, what I argue in the book is if you look at the justices who were regarded as great justices, they basically didn't have things like constitutional theories of the sort that we have now. They had ideas that were sort of similar to some of the things, but they didn't commit to any one thing. What their real characteristic was of the great justices are what I call wide experience and intellectual curiosity. And I focus, it's easiest to focus on the wide experience. If you look at the great justices, they're not people who spent their careers as appellate advocates or appellate judges. They were active in high levels of the national politics. John Marshall, who always comes up first on the list, was a member of the House of Representatives and Secretary of State and close advisor to George Washington. My guy, Charles Evans Hughes, had run for the president, had been governor of New York. Earl Warren had been governor of California, a vice presidential candidate. They weren't all involved in politics. Louis Brandeis was the premier public interest lawyer of his time.
Abe Fortas, is sort of one of the preeminent figures of the New Deal. So I think you're totally right, and there's been a cultural shift. Maybe you would point to the 80s and Justice Scalia and the Reagan administration's very careful attempt to pick certain kinds of judges, but this has become, along with the real dominance of a certain academic mindset, a really big question. And, a lot of senators, I'm not asking you how you'll rule in a certain case, but theories of interpretation, that's what we want to know about. So I think you're suggesting, hopefully actually, let me just say, hopefully we won't for many years. But if we do wind up talking about a vacancy, we, I think we'll look at this question that they'll try to get at. What sort of judge are you? Anyway, the book is Who Am I to Judge? A primer that we should all have around if and when a vacancy comes out. Let me just, this is total from the sublime to the ridiculous, Mark, but do you have a sense of the sort of rumor mill you live in Washington? People think with Trump's election and his general churlishness that maybe Alito and also Thomas might be thinking of retiring come June. And any suppositions there at all?
No, it's the sort of general buzz is, yeah, they might.
Yeah.
A lot will depend on how they feel about their lives and how they're going and what the prospects are of, for example, Democrats retaking the Senate in
Right.
2026. So, there's a
Fair enough.
personal
Yeah.
assessment that you can't really get into. An outsider really doesn't have access
Yeah. And not why you're the William Nelson Cromwell Professor of Law Emeritus.
to.
Okay, but let's switch over to this. Isn't all. Thank you so much for being here. This also isn't exactly why you're the William Nelson Cromwell Professor of Law Emeritus at Harvard, but it's certainly up your alley in its constitutional law and other legal overtones. And obviously, you're a very interested observer. So, there's sort of 7 or 8 universities that are in play, but I'd like to take the 2 paradigms that are there. One is Columbia, and let's put that to the side for now. And the other is Harvard, which came out in a very kind of muscular way with a hell no letter from the president to the administration and a lawsuit. Can you give us just, your sense, kind of orient about what they're saying is in fact not just objectionable, which I think is pretty easy to see, but unlawful about what the administration is trying to do with it?
It's actually sort of hard to figure out what the legal basis, the claimed legal basis of the administration's position is, because the demands that were rejected were so broad. The letter comes from something called the Commission or whatever it is on antisemitism,
Right.
and that suggests that they're invoking what's called Title VI of the Civil Rights Act, that says federal recipients of federal funds can't discriminate on the basis of race or national origin, and it's generally accepted that national origin includes anti-Semitism. I actually think that's a closer question than everybody else does. So
Well, just tell us. I mean, yeah, it's an amazing set of demands hooked to that peg.
One aspect of this, issue is, first, there's a lot of statutory questions about what you can do. They're saying we're freezing funds. We don't have to give you this money. We can impose conditions on it. One of the
billions of dollars. Yeah,
you're right. And one of the conditions is don't discriminate on the basis of race and national origin. That's fine. But one of the demands that just is completely weird is that Harvard would have to survey every faculty member and every prospective hire for plagiarism. What that has to do with discrimination on the basis of national origin is completely obscure. I mean, obviously, why they stuck it in is they succeeded in, or opponents succeeded in pushing Claudine Gay out nominally on the basis of her having done plagiarism, but that has nothing to do with anti-Semitism. Some of the others are a little more closely connected. They made a demand about restructuring the disciplinary system to take students off or to reduce the student roll, presumably because, I don't know what the theory is, that students are more likely to be anti-Semitic than members of the faculty. And it's just,
they want to fiddle with the curriculum and the academic plans of every department, right?
Right. If these were demands unconnected to federal funds, they'd be almost certainly unconstitutional interferences with we'd call it academic freedom or First Amendment rights of.
So you think it would be, let me posit 2 situations. One is there's some tenuous connection, but they purport to use it to, do billions and billions of dollars, including things that aren't germane. And the other is really no tenuous connection. It sounds like, no plausible connection. It sounds like in the second category, Mark, we see a sort of straight out First Amendment problem. Let me ask about the first. Is there law out there that, man, even if you have to say it in sort of layperson language, even if you have a legitimate point, you can't do $9 billion to remedy this problem, some proportionality notion?
Well, there is doctrine. It's incredibly confusing and contradictory. But to the extent that there's a doctrine that it goes along these lines, we don't have to give you this money. If we give you the money, we can tell you some things that you can do with it. And that's fine, right? We're giving you money to, carry out our programs. We can also, the doctrine seems to say, we can also tell you to do stuff that's sort of related to having this money, but we're not going to pay for it. You're going to have to do it on your own. So you use the word germane. The language of the cases seems to be something like, we can tell you to do things that are within the scope of the program that we're funding, but we can't tell you to do stuff that's outside the scope of the program. If we're giving you money to do a study of ophthalmology, is the thing that, I have no idea what the diseases of the eye would be, but if we're giving you money to do study of diseases of the eye, we can tell you, don't discriminate in connection with the study of the disease of the eye, but we can't tell you fire somebody in the divinity school. I mean, apparently this commission is very upset about programs in the divinity school. That's just not within the scope of the program that they're funding.
Okay, and I just want to underscore that's different from the basic notion of you can't tell a university what to do, academic freedom, which is a big part of free expression, First Amendment. This may be, maybe I need to call John Manning for this, whom I know you like and respect and whom I clerked with, the second in command at Harvard. But one of the really, to me, surprising and galling aspects of some of the more expansive assertions of power by the Trump administration is you lose, you win, you lose. So, they do this letter, and then by, 6 hours later, there's already been a withdrawal of certain funds. Do you have a sense of the kind of practical position that the university is in? I think my sense, and there's now been a complaint filed, is that they're pretty confident, as are, say, some of the law firms, that this is unconstitutional and they can beat it back. Do you have a sense of for them, the then what question? If they do beat it back, are they still, even more vulnerable to sort of capricious withdrawals of funding or whatever from the administration?
Well, so the answer is yes. I mean, if you piss them off, the next time you ask for money, they won't give it to you, and they'll come up with some, we're not as concerned about eye disease as we were before.
Right.
Okay. In the book, I actually talk about recount a story that the folk singer Arlo Guthrie uses. There are two rabbits who are being chased by a bunch of hound dogs, and they go into a log, and the dogs can't get into them. And one rabbit says to the other, "Well, what do we do now?" And the answer is, "We stay here until we outnumber them." It's a great. I mean, he does it much better than I do because he's a scholar. But one of the things that Harvard. Well, another version of this is Harvard was founded in 1636. It thinks it can outlast the Trump administration. Sure, there may be a couple of years where there'll be some stress on the university, but it's got a big endowment, and there are ways they can use it to get through the hard times. And then if there's a sigh of relief, they'll be
Yeah.
able to get back to normal. I think that's the strategy. They can't
Yeah.
expect favorable treatment going forward.
Yeah, and they are in that fortunate position. Princeton, similarly, with Chris Eisgruber, seems to be at least ready to take that tack. Let me ask you, because my sense, 84 law professors or however many sent an open letter. There was obviously a lot of push from the faculty and student body not to acquiesce in what feels like a kind of blackmail from the administration. And the letter that the president came out with is very strong. To the extent you have a sense of the internal process, was there a lot? Was it sort of driven from bottom up, or to the extent you have a sense of it, was Harvard never going to take this crap?
It's a combination of both of those, and you mentioned John Manning, who was a dean of the law school and very smart guy. He was a terrific dean of the law school. I clerked for Justice Marshall. He clerked for Justice Scalia. He was a terrific dean. I think that he has really good judgment. And I'm sure he had some input. I know he had some input into this kind of response. But there was also a lot of, there would have been, I think, a really explosive reaction from a very large portion of the faculty if they had done, what the letter demanded,
right.
Plagiarism.
It really, some of that was we haven't even covered it. And in the shout out to John Manning, I should say that, as you know, I clerked for Justice Marshall as well, but when he was clerking for Justice Scalia, and he was always a very straight up guy, I thought.
Talking Feds is supported by the Brennan Center for Justice. In this new political era, the Brennan Center will do what they do best: defend the Constitution and the rule of law. They're prepared to fight against presidential overreach and will continue advocating for reforms to resist weaponized government, stop billionaires from corrupting our elections, and ensure every eligible American has the freedom to vote. Stay informed by visiting brennancenter.org.
All right. Well, there's much more to talk about with Harvard, but I'd still, for time, like to switch and go to the Columbia model. So they've tried to capitulate, it seems to me. They're a well-heeled school as well, maybe not like Harvard. But I think they are arguably a sort of signal lesson in, it's never enough. There will always be sort of additional demands. And right now, I was struck, there is apparently a very serious discussion in the Department of Justice to try to put them in the position that the law under previous civil rights divisions have put rotten police departments, sort of rotten to their core, and bring a so-called, or get them to settle by signing a consent decree, a so-called pattern and practice allegation of violations that would permit a court basically to be telling Columbia what to do for many, many years. I've never heard of anything like that with a university, and it seems like the consequences could be grave and long-standing. But I wonder if you have any sense of where they stand in this kind of legal threat.
So there are a couple of things. One, there are settlement agreements under Title VI. University of Michigan has one. It's a letter from the Civil Rights Office in the Department of Education, which lays out a fair number of things that it says Michigan has to do, and Michigan agrees to do with them. Now, those are not.
And if they don't do, can the administration run to court, say, and get an order?
So no, these are, I think, they're conditions of
private,
continued funding. So it's the same thing. So the consent decree would be different, and I don't know of any that have been done, even in sort of most aggressive times of trying to desegregate Southern colleges
Yeah.
and universities. I just don't know of any. There might, as a cautious person, there might be one or two
Yeah, of
out
course.
there,
Right.
but they're certainly not prominent. One of the
And it's at the same time, by the way, as they're ceasing to do it in the traditional setting of police departments. Yeah.
so there's this one thing that I think I have to get out, which is a lot of this kind of discussion we're having is predicated on the idea that they have some, I just put a good faith. The Trump administration is acting in good faith in attempting to address anti-Semitism on campuses. And I myself, I have two thoughts. One is I'm very skeptical about whether they're acting in good faith. And second, I'm confident that the legal system is not well set up to deal with people who are systematically not acting in good faith. So
it's such an important and cross-cutting point. It's exactly what's happening in Abrego Garcia, where they are standing on a principle of deference to the executive, but it's assuming good faith on their part, and not to make too fine a point of it, they're lying through their teeth. And in that situation, in Abrego Garcia, when they're saying, "Oh, we don't have the power to bring them home," or it would be a terrible foreign policy thing, but that is. I think in general, people are always thinking about Dems and Republicans. I think in general, the big divide to have one's eye on is district courts and courts of appeals. And as you get up to the Supreme Court, the sort of concrete risk is really 5 votes, including the Chief Justice, for some principle that, for the real reasons you say, makes an ass of the courts and the law, which is, well, we can't question their good faith. When, of course, everybody knows that they're not only can you question it, but it's sort of not present. So much more to talk about. Let me just close with this, and hopefully we'll talk again, and including about who am I to judge if there is any Supreme Court kind of wrestling to come. But Professor Eisgruber, who, as you know, comes from a legal background, pronounced this the most vulnerable and frightening time for universities since the Red Scare. I wonder if you would agree, and what your general thoughts in a kind of historical sweep of the different threats there have been for universities today.
Yeah, I think that's clearly right. That Eisgruber is right, and in some ways it's more threatening because in the McCarthy era, the party configurations were such that there were Republicans who were against McCarthy. There were Democrats who were for McCarthy, but the party system was operating in a way that could constrain McCarthy. And it was McCarthy, not Eisenhower, who was doing this stuff. Now you have a president and a party system that is quite different, ideologically unified more or less on both sides and standing behind the president until things look like they may go south for Republicans. And so, yes, I think it's quite serious, except for the fact that it's at some level a serious. Columbia and Harvard are different in that Columbia's alumni network seems pretty clearly, I don't know if tilted in favor, but much more sympathetic to the Trump administration position than the Harvard alumni is. And the Harvard alumni, network is very powerful. This is anecdotally, one important actor who, in leading to Claudine Gay's departure, was Bill Ackman, who now tweets that whoever it is, Trump is crazy. Whatever he said, on the terrorist stuff. So I understand the political calculation going after Harvard. Net, probably a mistake, just because it is, a very powerful elite institution. That's why it's going after it. But power is very substantial.
Yeah, excellent point. And then on the Senate side, it's very hard to think of who would play the role of, at long last, have you no decency, right. Which I guess is that Helen Gahagan, whatever. But what arrested, because each and every senator seems beholden. Mark Tushnet, a real pleasure. I hope we can talk more. The book, 2 months old, Who Am I to Judge, has a lot about judging in general, but also about the sort of political battles of our day and whether they should remain so. Maybe we'll have a chance to discuss that and other kind of gnarly, if I can use the legal term, legal issues that confront us. Thanks so much for being here.
Thanks for the conversation.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.